Supreme Court of India Ghanshyam Soni vs. State, Government of NCT of Delhi, and another decided on June 4, 2025 0 NSC 803 facts of the case. As per the FIR, the marriage between the appellant husband and the complainant wife, respondent number 2 herein was solemnized. At the time, both the parties were serving as sub-inspectors with the Delhi police pursuant to the said complaint. FIR number 1098/2002 dated December 19, 2002 was registered under sections 498A, 406 and 34 IPC. Against the appellant husband and her in-laws, the magistrate framed charges under section 498A read with section 34 IPC and dropped the charge under section 406 IPC. The Sessions Court discharged the appellant, his mother and her 5 sisters for the offences under section 498A and 34 IPC. The High Court set aside the order passed by the Sessions Court. Findings of the court: the allegations against the family members, who have been unfortunately roped in, is that they used to instigate the appellant husband to harass the complainant wife, and taunted the complainant for not bringing enough dowry. However, there is no specific incident of harassment or any evidence to that effect. Similarly, the allegations against the 5 out of 6 sisters that they used to insult the complainant and demanded dowry articles from her, and upon failure beat her up, but there is not even a cursory mention of the incident. An allegation has also been made against a tailor named Bhagwat that he, being a friend of the appellant, instigated him against the complainant, and was allegedly instrumental in blowing his greed. Such allegations are merely accusatory and contentious in nature, and do not elaborate a concrete picture of what may have transpired. For this reason alone, and that the evidence on record is clearly inconsistent with the accusations, the version of the complainant seems implausible and unreliable. As regards the appellant, the purportedly specific allegations leveled against him are also obscure in nature. Even if the allegations and the case of the time, date or place, there is no incriminating material found by the prosecution or rather produced by the complainant to substantiate the ingredients of cruelty under section 498A IPC, as recently observed in the case of Jaydeepsinh Pravinsin Chavda and others versus State of Gujarat, 2024 INSC 960 and Rajesh Chadha versus State of Uttar Pradesh, 2025 INSC 671. The complainant has admittedly failed to produce any medical records or injury reports, X-ray reports, or any witnesses to substantiate her allegations. We cannot ignore the fact that the complainant even withdrew her second complaint dated December 6, 1999 6 days later on December 12, 1999. There is also no evidence to substantiate the purported demand for dowry allegedly made by the appellant, or his family, and the investigative agencies in their own prudence have not added sections 3 and 4 of the Dowry Prohibition Act, 1961 to the charge sheet. In this respect, the Sessions Court has applied its judicial mind to the allegations in the FIR and the material on record, and has rightly discharged the appellants of the offences under section 498A and 34 IPC. It is rather unfortunate that the complainant, being an officer of the state, has initiated criminal machinery in such a manner, where the aged parents-in-law, 5 sisters and 1 tailor have been arrayed as an accused. Notwithstanding the possibility of truth behind the allegations of cruelty, this growing tendency to misuse legal provisions has time and again been condemned by this court. Considering the date of commission of offense as September 8, 1999 and the date of filing of complaint as July 3, 2002, this court finds that the complaint was lodged by the petitioner within a period of 2 years and 10 months from the date of commission of alleged offense, which is within the period of limitation of 3 years as per section 468 of CRPC. It is therefore clarified that the magistrate had rightly taken cognizance of the offense under section 498A. We deem it fit and appropriate to quash and set aside the FIR and the charge sheet.